July 3rd, 1865. Just months after the Civil War ended, the town board of Opelousas, Louisiana gathered to pass an ordinance, not to celebrate freedom, not to welcome newly emancipated people into citizenship, but to cage them with words. Section 1 read, "No Negro or freedman shall be allowed to come within the limits of the town of Opelousas without special permission from his employer, specifying the object of his visit and the time necessary for the accomplishment of the same." Section 2. Every Negro or freedman who shall be found on the streets of Opelousas after 10 o'clock at night without a written pass shall be imprisoned and compelled to work 5 days on the public streets or pay a fine of $5. Section 3. No Negro or freedman shall be permitted to rent or keep a house within the limits of the town under any circumstances. These weren't suggestions. They were laws, printed, bound, filed in dusty courthouse record books alongside property deeds and marriage licenses. And here's what should chill you. They weren't anomalies. Across Louisiana, from the smallest rural parish to the streets of New Orleans, local governments raced to codify a new form of bondage. They called them black codes, but they were nothing less than slavery by another name. What's more disturbing? Some of these laws never disappeared. They sat in those record books, legally on the books, for over 100 years. While America celebrated civil rights victories, while the nation moved forward, these ghost laws remained hidden in plain sight, waiting in courthouse basements and forgotten shelves. This is the story of how the architecture of slavery outlasted the chains themselves. Let's go back to that moment in 1865. The 13th Amendment had just abolished slavery. 4 million enslaved people were suddenly legally free. The Confederacy had lost. The war was over. But in Louisiana and across the South, white lawmakers saw emancipation not as justice, but as a problem to be solved. St. Landry Parish, where Opelousas sits, wasted no time. The parish police jury convened and drafted Ordinance number 35. It read like a manual for control. Freedmen had to have jobs. Approved by white employers, they needed written passes to travel. They couldn't own certain businesses. More than 3 African Americans couldn't gather in public without permission. And here's a detail that reveals the true intent. The ordinance gave any white citizen the legal authority to act as a police officer, to detain, to enforce these rules. The town of Franklin passed similar codes. New Orleans, Shreveport, Baton Rouge, rural parishes across northern and eastern Louisiana, they all followed suit. These weren't rogue actions by extremist town councils. This was coordinated, systematic, a blueprint for subjugation. Thomas Conway, the Freedmen's Bureau Commissioner for Louisiana, testified before Congress in 1866. He said local officials were issuing slave codes and ordering subordinates to enforce them with the full knowledge of state officials. The federal government protested. Northern newspapers called it outrageous, but Louisiana officials simply ignored them. See, the black codes exploited a legal gray area. The 13th Amendment banned slavery, except as punishment for crime. So Louisiana criminalized being black without a job. They called it vagrancy. If you were found without employment, you could be arrested, fined, and if you couldn't pay the fine, forced to work on public roads or leased out to private employers, it was convict leasing, slavery in new packaging. The codes dictated every aspect of life. You couldn't walk downtown after certain hours. You couldn't rent property. You couldn't carry weapons. You couldn't testify against white people in court. Interracial marriage was forbidden. If you violated these ordinances, you weren't just fined, you were impressed into labor gangs. Working the same plantations where you'd been enslaved months earlier, Wilkin Jones, curator of the Rural African American Museum in Opelousas, explained it plainly. The Black Code was a way of keeping former slaves on the plantation and keeping them under control. There was a fear that too much freedom would lead to turmoil. To be required to stay on a plantation of which you were once enslaved is unfair and inhuman. But here's where the story gets complicated, and where Louisiana's legal system became uniquely insidious. In response to outrage over the Black Codes, Congress passed the Civil Rights Act of 1866, then the 14th Amendment guaranteeing equal protection under the law, then the 15th Amendment guaranteeing voting rights for black men. Reconstruction brought federal troops, oversight, and for a brief window, real political power for African Americans in Louisiana. Louisiana elected black mayors, black lieutenant governors, black legislators. By 1875, almost 4,000 schools for black students had been established. Over 2,500 African Americans ran for office. It looked for a moment like genuine transformation. But white Louisiana was patient and strategic. When Reconstruction ended in 1877 and federal troops withdrew, the backlash was swift and brutal. The Black Codes hadn't disappeared, they'd just gone dormant. Now they evolved into Jim Crow. Louisiana began passing a new generation of segregation laws, but these were smarter, more careful. Instead of explicitly targeting Negroes and freedmen, the new laws used neutral language. They segregated public spaces, schools, transportation, but framed it as separate but equal. In 1890, Louisiana passed the Separate Car Act, requiring racial segregation on trains. When Homer Plessy challenged the law in 1892, the Supreme Court upheld it in Plessy v. Ferguson, giving legal cover to segregation nationwide. By 1898, Louisiana ratified a new state constitution written explicitly, and I'm quoting here, to establish the supremacy of the white race. It included poll taxes, literacy tests, and other mechanisms to strip black citizens of voting rights. It allowed non-unanimous jury verdicts, meaning a single black juror couldn't stop a wrongful conviction. That provision alone would remain in effect until 2018. But the parish and municipal codes, those original Black Codes and their descendants, they just kept accumulating. Louisiana passed more laws. In 1902, streetcar segregation. 1908, interracial marriage bans. 1918, prison segregation. 1921, housing segregation. 1928, public carrier segregation. 1932, more anti-miscegenation laws that nullified interracial marriages even if performed in other states. 1942, segregated old age homes. 1945, renewed bans on interracial marriage with specific prohibitions on Native Americans marrying black people. 1951, laws against interracial cohabitation with penalties up to 5 years imprisonment. 1952, 1954, 1956, 1957, 1958, on and on. Each law was printed, codified, and filed away in record books. In 1956, Louisiana mandated separate bathrooms for white and black employees. The law required signs posted in conspicuous places. Violators faced fines and imprisonment. That same year, the state banned any business from allowing black and white people to participate together in dancing, sports, games, or social functions. In 1958, and this one is particularly macabre, Louisiana required that all blood used for transfusions be labeled Caucasian, Negroid, or Mongoloid to indicate the donor's race, because apparently even blood had to be segregated. Most of these state laws were on the books through the 1950s and into the 1960s. And remember, beneath them sat layers of parish ordinances and municipal codes, many dating back to the 1860s, that were never formally repealed. They just sat there, in county record books, waiting. Now, you might think, okay, but nobody actually enforced those old laws, right? And that's partially true. By the 1960s, direct enforcement was rare, but their existence mattered. They created a legal architecture, a framework that told black Louisianans where they stood. The laws were psychological weapons as much as legal ones, and when civil rights activists began organizing, those old laws were still there, ready to be invoked. When students staged sit-ins in 1960, they were arrested under segregation statutes. When voters tried to register, they faced laws designed to disenfranchise them. When parents tried to enroll their children in white schools, they hit walls built by decades of codified racism. The attorney, Alexander Pierre Tureau, spent 50 years fighting Louisiana's segregation laws. Starting in the 1920s, he filed lawsuit after lawsuit with the NAACP. He sued for equal pay for black teachers. He sued to desegregate schools, universities, buses, parks, public buildings. He won voting rights cases. In 1940, he won McAlpin versus Orleans Parish School Board, securing equal pay for all public school teachers regardless of race. Each victory chipped away at the system. But Tureau and lawyers like him faced a Sisyphean task. Every statute they overturned seemed to spawn two more. Louisiana's resistance was relentless. When the Supreme Court ruled in Brown versus Board of Education in 1954, declaring school segregation unconstitutional, Louisiana responded by amending its constitution to mandate that schools operate separately for white and black children. The penalty for not enforcing segregation, $500 to $1,000 and 3 to 6 months imprisonment. Ruby Bridges became the first black child to integrate an elementary school in the South when she attended William Frantz Elementary in New Orleans in 1960. She was 6 years old. Federal marshals escorted her to school every day for a year because of the threats. That's how deeply segregation was embedded. That's how far Louisiana would go to resist change. The Civil Rights Act of 1964 and the Voting Rights Act of 1965 were supposed to end this. Federal law now banned discrimination. Segregation was illegal. The Jim Crow era was over, at least on paper. But in Louisiana, change came in geological time. In 1965, only 5 of Louisiana's 64 parishes submitted plans for school integration. By 1967, 30 parishes still hadn't made any arrangements to desegregate. In 1970, 45 parishes were ordered to create legitimate integration plans or lose federal funding. Full integration of Louisiana's public schools didn't happen until the mid-1970s. And those old ordinances? The black codes sitting in parish record books? Many were never formally repealed. Civil rights lawyers would discover them while researching cases buried in municipal code books that hadn't been updated in decades. They'd find ordinances from the 1860s, 1870s, 1890s, still technically on the books. Laws dictating where black people could walk, when they could travel, what businesses they could own. Laws giving white citizens authority to detain black residents. Laws mandating passes and curfews. The lawyers would bring these discoveries to light, often shocking local officials who had no idea these relics still existed in their legal codes. Some parishes quietly repealed them, others dragged their feet. The process was piecemeal, uncoordinated, often incomplete. What made Louisiana's situation unique was the sheer volume of these laws and how deeply they were embedded in local governance. Louisiana operates under a civil law system inherited from French and Spanish colonial rule, unlike the common law system in the rest of the United States. This meant Louisiana had a particularly dense, layered legal code. Municipal ordinances, parish regulations, state statutes, and constitutional provisions all stacked on top of each other, creating a legal thicket that was difficult to navigate and harder to dismantle. By the 1970s, lawyers working on civil rights cases would sometimes stumble upon these forgotten laws while researching. They'd be looking for precedents, going through old code books, and find entire sections dedicated to racial control. It was like archaeological excavation, except the artifacts were still legally valid. The discovery process often went like this. A civil rights attorney would be working on a discrimination case, digging through parish records for evidence. They'd flip through bound volumes of ordinances, past zoning laws and business licenses, and suddenly find pages of black codes, regulations on movement, prohibitions on assembly, restrictions on property ownership, all written in the formal bureaucratic language of law, as if controlling human beings based on skin color was just another administrative function. These attorneys would flag the ordinances, demand their repeal. Parish councils would express surprise, claim they had no idea those laws were still there. But the hesitation to formally strike them down was telling. Even when officials acknowledged the laws were wrong, unconstitutional, unenforceable, actually removing them from the books required action. It required votes. It required someone to stand up and say, "We're ending this officially, finally," and that was harder than it should have been. Some ordinances were repealed in the late 1960s and early 1970s as part of broader efforts to clean up legal codes. But there was no systematic statewide push to purge these laws. It happened parish by parish, town by town, when someone cared enough to push for it, which meant some laws lingered even longer. The persistence of these ghost laws illustrated something crucial about systemic racism. It's not just about active discrimination. It's about the infrastructure of oppression that remains even when explicit enforcement stops. Those laws created generations of inequality. They shaped where people lived, what schools they attended, what jobs they could get, what wealth they could accumulate. Even when the laws weren't enforced anymore, their effects compounded across time. Consider a black family in Louisiana in the 1870s, unable to buy property because of municipal codes. Their children grew up renting, unable to build equity. Those children, now adults in the 1900s, faced new Jim Crow laws limiting their opportunities. Their children, growing up in the 1920s and 1930s, attended underfunded segregated schools because of laws mandating separate education. Those children, adults by the 1950s and 1960s, tried to register to vote, but faced laws designed to disenfranchise them. Their children, the generation coming of age in the 1970s, inherited the poverty, the lack of property, the educational gaps, all the compounded disadvantages created by a century of legal oppression. This is what civil rights activists meant when they talked about structural racism. It wasn't just individual prejudice. It was a legal system designed from the ground up to maintain white supremacy. And even when the laws stopped being enforced, even when they were theoretically invalid, they left behind patterns of inequality that persist to this day. Louisiana's northern parishes where black codes were most aggressively enforced, remain some of the poorest areas in the United States. The wealth gap between white and black families in Louisiana is one of the widest in the nation. Educational outcomes, incarceration rates, health disparities all still map onto the geography of Jim Crow. The ghost laws also revealed how invested white Louisiana was in segregation. Think about it. These ordinances could have been repealed at any time after they became unenforceable, after Reconstruction, after Brown versus Board of Education, after the Civil Rights Act. But they weren't. They stayed on the books because no one in power cared enough to remove them. Or maybe because some people wanted them there, as a reminder, as a threat, as a statement that even if the federal government said otherwise, Louisiana still believed in the principles those laws represented. It took civil rights lawyers actively discovering and challenging these ordinances to get them repealed. It took public pressure and outrage. It took people saying, "This is unacceptable. These words cannot remain in our legal code." And even then, the process was slow and incomplete. Today, if you visit Louisiana parish courthouses, you can sometimes still find those old code books. They're kept as historical records now, not legal documents. You can flip through them and read the ordinances, see the language, feel the weight of what they represented. The Opelousas Code is particularly striking. Sections 1 through 13 laying out the complete control of black residents. Section 11 specifies that all provisions apply to both freedmen and freedwomen. Section 12 makes it the special duty of the mayor to ensure faithful execution. Section 13 states, "The ordinance takes effect immediately upon publication." Ordained July 3, 1865. There's something about seeing these laws in print that makes them visceral. They're not abstract history. They're concrete, deliberate, institutional. Someone sat down and wrote these words. Someone approved them, someone filed them, and they sat there in official legal code for over 100 years. The story of Louisiana's black codes and their persistence into the 1970s is a story about how oppression codifies itself, how it embeds in institutions, how it outlasts generations, how you can abolish slavery but not the architecture built to support it. It's also a story about resistance and persistence, about lawyers like Alexander Pierre Tureau, who spent their entire careers dismantling this system case by case, law by law, about activists who sat in, marched, organized, voted, despite the laws meant to stop them, about children like Ruby Bridges who walked through screaming mobs to attend school, about ordinary people who refused to accept the limits placed on them by words and books written by people who thought their humanity was negotiable. The civil rights movement succeeded in overturning Jim Crow, but it succeeded slowly, painfully, incompletely. Laws changed, but systems and attitudes lagged behind. Even today, Louisiana grapples with the legacy of its black codes. In 2018, Louisiana voters finally abolished the exception for non-unanimous jury verdicts, a provision rooted in the 1898 Constitution's explicit white supremacy. In 2020, the Supreme Court ruled such verdicts unconstitutional nationwide. It took 122 years to undo that particular piece of the Jim Crow architecture. The lesson here isn't just historical, it's ongoing. Systems built on injustice don't collapse when the injustice is declared illegal. They adapt. They find new forms. They persist until actively dismantled, piece by piece, word by word. Louisiana's black codes were written to trap people in subordination. They succeeded for over a century, not through active enforcement alone, but through the simple fact of their existence. They shaped reality, created barriers, justified violence, and left scars that haven't fully healed. Understanding this history matters because the work of dismantling racist systems isn't finished. It requires vigilance, activism, legal challenges, political will, and public pressure. It requires looking into dusty record books and asking what laws still sit there, what policies still perpetuate inequality, what structures still reflect the values of people who believed some humans mattered less than others. The ghost laws of Louisiana taught us that abolition isn't enough. Legislation isn't enough. Even constitutional amendments aren't enough if the infrastructure of oppression remains intact. Real change requires going into those courthouses, opening those record books, and striking out every single word that denies someone's humanity. Every ordinance, every statute, every code. And it requires doing more than erasing words. It requires building new systems, creating actual equality, repairing the damage done by generations of legal oppression. Louisiana's story shows us how deep the roots of racism run, but it also shows us that those roots can be pulled up, one law at a time, one lawsuit at a time, one generation at a time. It's slow, it's hard, but it's possible. The black codes sat in those record books for over 100 years, but they're gone now, struck from the legal code, not because they faded away on their own, but because people fought to remove them. That fight continues because the architecture of oppression is still being dismantled, and the work of building true equality is still unfinished.